Hey guys, so I had a request to review Davis v. Davis, which is the subject of your assignment this week. So if you want to grab your case, we can look through it a little bit. The case starts off with an introduction talking about Mary Sue and Junior Davis, who were married for a period of time, went through the IVF procedure, and developed some embryos. Mary Sue attempted to use one embryo and had that implanted, but it didn't take, and the other four were cryogenically frozen for a later date. The couple then divorced, and since that time, Mary Sue at first wanted to use the embryos to become pregnant herself, and she was not allowed to do that. Junior objected, saying that he didn't want to become a parent with someone he wasn't married to. So then later, she remarried and he remarried, and she wanted to donate those embryos to a childless couple so that they could use them to become parents. So that is where our case begins. And if you look over to the facts, it's under Roman numeral 2. That will kind of go through what happened. It goes through, she had a really tough time becoming pregnant. She had a couple of tubal pregnancies that had to be terminated. She went through 6 rounds of IVF, which it looks like was pretty costly, about $35,000. On to the next page. At some point in time after they had those embryos frozen, he wanted a divorce. She thought there wasn't an issue, but they did ultimately get divorced. And then the court begins to talk under Roman numeral 3 about the legal status of the embryos. So they have a couple of experts that they consult. The first is Dr. Jerome. I don't speak French well, so I'm not going to say his last name. We'll just call him Dr. Jerome. Dr. Jerome indicated that 4 to 8 celled entities at issue are early human beings or tiny persons. So he believes that they are human beings from the point of conception. Dr. Irving Ray King disagreed, and he indicated that pre-embryos are a different entity altogether up until 14 days after fertilization, when the cells begin to differentiate. And that's when they become an individual. So before that time, he would not call them individual human persons. The American Fertility Society seemed to agree with him and indicated that at 8 cell stage, the developmental singleness of the embryo, the individualness of that entity hasn't been established. The trial court, in this case, originally when it went to trial, said that they were human beings at the moment of conception, and so they awarded those embryos to Mary Sue because she wanted to give them life. The Court of Appeals disagreed. It rejected that reasoning and indicated that they were more of property than they were individual persons. So then the court gets into the person v. property argument about that legal status in Roman numeral 4, and indicates that under Tennessee law, the embryos cannot be deemed as persons because they couldn't be the subject of a wrongful death statute. And it says the statutory scheme indicates that as embryos develop, they're accorded more respect than mere human cells because of their potential for life, but even after viability, they're not given the legal status equivalent to that of a person already born. And that language really echoes the language that we saw in Roe, when they discussed whether or not that the unborn fetus was a person or was not a person. In Roe, they looked at the interpretation of the Constitution, and individuals were not called persons until they had been born, and thus were not accorded rights as Americans until they had been born as persons. And so the Tennessee law sort of echoes that sentiment from Roe. Moving on, the trial court said they were persons. The intermediate court saw them a bit more as property, relying on that York v. Jones case, which this court found to be a little bit troubling. It didn't really care for them being called persons, didn't think that was appropriate. So it looked to the American Fertility Society's ethical standards, and there was 3 that were presented there. The first indicated that it was a human was a human from the moment of fertilization. The second indicated that a pre-embryo was just like a clump of cells, so it should be viewed as any other type of tissue in the body, and thus was not especially special and didn't need any special protections. And the third view that they held, that seemed to be the most widely held, took sort of an intermediate position, and it held that the pre-embryo deserves respect greater than that accorded of human tissue, but not the respect accorded to actual persons. And this is the view that the court decided to adopt. If you look over at 63, it says, we conclude that pre-embryos are not, strictly speaking, either persons or property, but occupy an interim category that entitles them to special respect because of their potential for human life. So that's the legal status that they gave to the embryos. They weren't given the rights as persons, but they also were given more respect than property because of their potential to become persons. Moving along to the enforceability contract. So here the court is just talking about if the parties had made some sort of agreement about what to do with the embryos in the event of divorce or in the event of the death of one of the spouses. And they discussed that they would look to that contract first, and they would have used it not necessarily ironclad, because sometimes circumstances change, but they would have certainly looked to that first. But they did conclude there was no initial agreement between the parties concerning disposition of the embryos under the circumstances of this case. There was no agreement since, and there is no formula in the Court of Appeals opinion for determining the outcome if the parties cannot reach agreement in the future. So that didn't really apply here, but they just wanted everyone to know that they would have looked to that first had it been available to look at. And really, in a case like this, even if you think it's not a possibility, it is something that you should do. So moving on to the right of procreational autonomy, they're talking about, do you have a right to determine if you're going to be a parent? Does that fall under the privacy rights that we have? So the court talks about what's in the Constitution and what's not. Looking at 75, without a doubt, it demotes merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized that common law is essential to the orderly pursuit of happiness by free men. So he's saying we kind of have the basis for this, and then as they continue that discussion, you'll see they look down at Eisenstadt v. Baird, where they say, if the right of privacy means anything, it's the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So as they discuss it, they're getting there. Yes, this is something that is a fundamental right for us to decide whether or not we do choose to have children. They also looked at Griswold v. Connecticut. A right of procreational autonomy is inherent in our most basic concepts of liberty, is also indicated by the reproductive freedom cases. And they talk about Roe v. Wade, Griswold v. Connecticut, and a number of other cases. So they talk also a little bit about, which is important, the two progenitors, Mary Sue and Junior, and what they went through with the process of IVF. So they said that even though Mary Sue had gone through probably more physically, emotionally, because she had to take the hormones, like she had to do the things, right? That both she and Junior were going to be given equal weight in the decision because, the embryo really belongs to both of them. It contains both of their genetic material. So what they concluded is, they said, we conclude, moreover, that an interest in avoiding genetic parenthood can be significant enough to trigger the protections afforded to all other aspects of parenthood. The technical fact that someone unknown to these parties could gestate these pre-embryos does not alter the fact that these parties, the gamete providers, would become parents in that event, at least in the genetic sense. So, then they move on to, under Roman numeral 7, talking about balancing the parties' interests, how they're going to weigh Mary Sue's interests and Junior's interests. And they speak more a little bit about Junior's interests. He was one of, 6 children, and his parents got divorced when he was younger, and he had a really hard time with it. And he feels very strongly that he doesn't want to bring a child into a home that does not have both parents. And so the court talks about that, and it gives, a good amount of weight and balances how he feels about that and his rights with Mary Sue's. And they ultimately decide that Junior has the right not to be a parent if he so chooses. It says the case would be closer if Mary Sue Davis was seeking to use the pre-embryos herself, but only if she could not achieve parenthood by any other means. She would have a reasonable opportunity through IVF to try once again to achieve parenthood in all of its aspects, genetic, gestational, bearing, and rearing. They say also, even if she wasn't able to do IVF again for whatever reason, she would still have the ability to adopt, and so she could achieve parenthood through those means. And so, unless for some reason somehow there was no other way that she could become a parent, they probably would rule in favor of Junior, who does not want to become a parent in that way. So, in conclusion, they say if the wishes cannot be ascertained or if there is a dispute, then the prior agreement concerning disposition should be carried out. If there had been a prior agreement, here there was not. If no prior agreement exists, then the relative interests of the party in using or not using the pre-embryos must be weighed. Ordinarily, the party wishing to avoid procreation should prevail, assuming that the other party has a reasonable possibility of achieving parenthood by means other than the use of the pre-embryos in question. If no other reasonable alternative exists, then the argument in favor of using the pre-embryo to achieve pregnancy should be considered, so you could weigh it in that circumstance. However, if the party seeking control of the pre-embryo intends merely to donate them to another couple, the objecting party obviously has the greater interest and should prevail, and that was the case here. She wanted to donate the embryos to another couple, and so Junior's interest in avoiding parenthood prevailed. In this case, the Knoxville Fertility Clinic was free to follow its normal procedures in dealing with unused embryos, as long as that procedure is not in conflict with this opinion. So they would just dispose of them however they generally dispose of embryos. And that was the ultimate outcome. Hopefully this was helpful, guys. Thank you.